From the Library of Congress in Washington, D.C.
So this is our fourth day of hearings for the Section 1201 rulemaking. This is the seventh rulemaking process. And this topic is Class 12 3D printing. The Register of Copyrights has already determined she can presumptively recommend renewal of the current exemption, and so we're focused mainly on expansions or modifications to that language. And before we dive into the 3D printing issues, I did want to say if there's anyone in the audience who wishes to participate in audience participation, and there may not be, but we have a sign-up sheet in the back. If you could add your name to it, if possible, we're going to try to bump that up, being mindful of our time. So we will introduce ourselves here and then have the participants introduce themselves. If you'd like to speak, tip your placard up, or there's two of you, just indicate. And we're trying to just focus on honing in on the issues based on your written comments. So Mr. Sloan, if you wanted to introduce yourself.
Yes, I'm Jason Sloan, Attorney Advisor in the General Counsel's Office of the Copyright Office.
Kevin Amer, Senior Counsel in the Office of Policy and International Affairs at the Copyright Office.
I don't recall if I introduced myself, but I'm Reagan Smith, the Deputy General Counsel.
John Riley, Attorney Advisor, Copyright Office.
Emma Kleiner, Ringer Fellow at the Copyright Office.
And I'm Rafi Goldberg. I'm a policy analyst at the National Telecommunications and Information Administration, or just NTIA.
Mr. Weinberg, do you want to introduce yourself and also explain any affiliation or interest you have with 3D printing exemption?
Sure.
It's, if you press the button, it should turn on. Is it working? Yep.
So it does. I'm Michael Weinberg. I'm here in my personal capacity. When I was working at the public interest organization Public Knowledge, I submitted earlier versions of this petition in earlier rounds, and so I am continuing it even though I'm no longer connected with Public Knowledge.
Do you have any financial interest with the 3D printing industry or anything?
I am the general counsel of Shapeways, which is a 3D printing company. Shapeways, to be clear, Shapeways takes no position on this issue, but I'm employed by Shapeways.
Okay, but you're here in your personal capacity.
Yeah, absolutely.
Okay, thank you.
And I'm Gina Chapman. I'm here representing...
Oh, sorry, now it's live. I'm Gina Chapman. I'm here representing Stratasys. We're a manufacturer of 3D printers, and I'm employed by Stratasys as its in-house senior IP legal counsel.
Okay, thank you. So to tip it off, maybe Mr. Weinberg, you could explain what types of non-infringing uses you think are being prevented or, hamstrung by the language and the current exemption.
Yes, thank you, and thank you. I really appreciate the structure of this this process this time around. I appreciate that there's the opportunity to ask for a renewal of the original exemption request, and that was a streamlined process, and that we're now able to focus on, I think, what I hope is a relatively modest expansion of the request. And so my concern with the reason that I'm asking for an expansion of the request, my concern with the language as is written in the previous exemption, is that it's language that involves a great deal of ambiguity and does not involve a great deal of clarity around when the exemption could actually apply. So I have sort of two sets of concerns, and then I'll talk briefly about what's the result of those concerns. First of all, it appears that the additional language that was included in the request that I'm requesting to be removed was driven by a concern that was actually not voiced by the regulatory agencies at the time. The 2015 exemption cites a letter from the FDA that purported to raise concerns about the use of 3D printers in relation to medical devices. In fact, that letter, I think upon close reading, does not raise the concerns that are used to justify the exemption. And to the extent there are other concerns related to airline safety or other medical devices, those concerns may or may not be legitimate. I'm honestly not in a position to evaluate them, but I think that those concerns are well beyond the scope of this proceeding and the Copyright Office generally. The second thing is that the language creates a distinction between commercial and non-commercial uses of 3D printers that simply is not sustainable in everyday use. This was actually raised as a question during the last proceeding, and both myself, Public Knowledge, and Stratasys weighed in and made it clear that this distinction is very hard to make because, first of all, an individual printer can be used at one moment for a personal use, for another moment in commercial use. And the way the language is tied, it appears to attach to any printer that is used to create an object that is regulated in any way.
So I want to put a pin in questioning on that contention for a section and go back to whether you have responses to my question, which is, are you aware of any non-infringing uses, or what are the things that are being precluded from using alternative feedstock by the language in the current exemption?
Yeah, I apologize.
Sure.
So the uses of alternative feedstock is, again, as we said in 2015, I don't actually believe it is prohibited by by Section 1201, but there's enough ambiguity that we requested that the exemption be granted because there is remaining ambiguity. The behavior that is being prohibited or prevented is the general use of people being able to what they believe is jailbreaking their 3D printer. So any 3D printer that is owned by an individual where they want to bring third-party feedstock, the ambiguity around the language in the current exemption can prevent them from doing that because it is very hard to determine if they fall within or without that exemption because of the way that the language applies to everyday use.
I think there was some confusion, at least with Stratasys, because just to be clear, are you proposing to eliminate all the language after provided however in the existing exemption?
Yes, the language that I want to remove is the language that I would describe as the kind of qualifying language in the exemption. And the goal is to remove that qualifying language. I think the specifics of how that is removed is something that there is space to consider. But the idea that it is qualified by the language that it shall not extend any computer program or 3D printer that produces goods or materials for use in commerce, the physical production of which is subject to legal or regulatory oversight or related certification process, or where the circumvention is otherwise unlawful. And I think that or where the circumvention is otherwise unlawful is language that is, I think it adds ambiguity, but the primary concern is the language that precedes that talks about any goods or materials that are used in commerce that are subject to legal or regulatory oversight, which can easily be read broadly enough to include, all things.
Well, I think that language was put in based on the record in 2015, and the record was based on a lot of, testimony that users active in the makers movement or so forth, wanted to use alternative filament for, innovative purposes. But none of that was really relating to purposes subject to what we would saw as any regulatory oversight. It would be helpful if you could narrow in on, you say the language is ambiguous, but any tangible examples, because I don't think you're here because there's a desperate need to make alternative airplane parts.
No, as someone who's flying later on today. I think that, so the distinction between individuals in the maker movement and individuals who are engaged in commerce is one that is not a clear distinction. And so when we talk about evidence in the record of people who are involved in that maker movement being negatively impacted, those people are often engaged in commerce.
Well, I guess the current language doesn't just say for use in commerce, like it doesn't say if you put what you made on Etsy, you can't do it. It says the physical production of which is subject to legal or regulatory oversight or related certification. So I think the office saw that as limiting, and we would like to understand why that is an obstacle, I guess, to non-infringing uses and demonstrate seeing that there is an adverse effect.
Of course. So I think that the language related to subject to legal or regulatory oversight all items that are in the stream of commerce are subject to legal or regulatory oversight. I mean, there are legal regimes that govern everything that is used in commerce. And so to the extent that language was intended to narrow the scope of this exemption to the exemption to things that are regulated in the sense by the FDA or the FAA, I think that the language, the specificity of that language is lacking. And it doesn't provide the clear lines of subject to oversight by a specific regulatory agency or oversight by in a specific protocol. And I think part of the reason for the breadth of that language, I wasn't there to draft it, is that it is in fact very hard to draft language that specifies those types of regulatory regimes in a way that would be inclusive of what you might want to cover, but exclusive of things that you would have no intention of covering. And the good news is that that's an exercise that is very complicated, but is largely unnecessary, because those objects are going to be regulated by those existing regimes. And so it is unlikely that the safety of airline parts or the safety of medical devices, those don't turn on whether or not the 1201 exemption applies to machines that could potentially be used to manufacture them.
So going back to our original question, and maybe just if we could flush this out a little bit, I guess specifically, are people who are using this exemption looking to make airplane parts or medical devices? Is an exemption that specifically talked about the FAA or FDA, better than what we have now? Can you tell me more about your uses?
Yeah, I think that I don't have the survey data of all 3D printer users, and I'm not suggesting that you're requesting that, but I don't have that information. I think that the answer is it may, but I don't understand the Copyright Office's role of carving out things related to those type of regimes. I mean, I'm not sure.
Well, I'll say again, I think we're trying to determine whether exemptions are warranted based on the non-infringing uses that people come forward and say they would like to engage in, and I think that was a primary a driving factor in why the current exemption is how it is. And also, I don't mean to cut you off now, but I do want to say if Ms. Chapman ever wants to jump in, there's only two of you, so just feel free. We're not meaning to just focus on Mr. Weinberg.
Yeah, so I think that it's unclear, right? I mean, there is a movement of people who are making medical devices with 3D printers, and I think that as the record from the last proceeding made clear, as Stratus's own comments in response to questions the last time around made it clear, there's a spectrum and range of users that are very hard to differentiate from the individual who's making stuff simply for themselves at home all the way to large industrial players. And so you do see smaller companies who are doing things in the medical field with 3D printers. I mean, the FDA has been having a years-long review of that process, where they are using printers in ways that are connected with medical devices. And while I think it is true that it is possible that if you were to use unapproved third-party materials in a 3D printer, it could create problems, it's also true that it could not create problems, and that the manufacturers, the users of these machines, should have the leeway to determine if they're able to meet the FDA standards for the devices they're making on the machines. It's unclear to me why a 1201 prohibition against that process, what purpose that would serve. And similarly with the FAA, I
appreciate your point philosophically, but our task here under Section 1201, since there is a blanket prohibition on the circumvention of access controls protecting the copyrighted work, there just is, we can recommend and the librarian can adopt exemptions to that just based on non-infringing uses. So that's what we're here looking at as part of this proceeding. So the more you can tie it into the standard that we're trying to look at, the more helpful it will be. Thank you.
Sure, I appreciate that. I mean, and if it is helpful, I'm happy to follow up with specific examples or other users. I think that those users as a class exist, and if there's a level of documentation that is necessary to find them, I think that that is a reasonably straightforward process.
Ms. Chapman, did you want to jump in?
Sure. So Stratasys disagrees with Mr. Weinberg that the current standard is ambiguous or unworkable. We find that it's clear that it was well thought out, that it was drafted after fully considering the record, after even soliciting post-hearing remarks from both parties. So we believe that the previous record is very well developed. There was evidence and testimony provided by Mr. Pat Carey on behalf of Stratasys as to the role that the TPMs play in providing a closed system and the safeguards that that provides in the manufacturing industry and regulating regulated industries such as aviation. And there was remarks given on the record then which are true today, and in fact even more true today from the advancements of the use of printed parts in those industries over the last few years. So the evidence of the record today is even more strongly in favor of continuing the exemption with the qualifying language rather than removing that. And there hasn't been any evidence presented of persons who are harmed. So as the petitioner seeking to expand an exemption needs to show that there are users who are adversely affected and there is some substantial non-infringing use that's being hindered. So I don't think there's been any evidence of this. There's maybe just some hypotheticals of persons who may exist, but I don't think there's any evidence that there's a user who owns and operates a 3D printer for both, hobbyist or non-commercial uses, and is also producing parts that are used for commerce and subject to legal or regulatory oversight. I don't know of any such users who are adversely impacted.
Can you talk more about what are the goods or materials for use in commerce produced on 3D printers that are subject to legal or regulatory oversight or a related certification process? And can you give additional examples, please?
Sure. Mr. Weinberg raised the medical devices. This is something really not in my area of expertise because we've been less involved in the certification proceedings there, and with the regulation, our clients are involved in that. But like personally, I'm probably not expert to explain what those rules are. And certainly the FDA has considered and has issued some guidelines on the use of 3D printers in that area. And again, it's more of our end users who are doing that. So I probably would be speaking beyond my expertise if I gave examples on that. But I think that there aren't any examples on the record of persons who are producing those commercial goods for medical devices that are also printing things in an unregulated industry. So I think that's important to keep in mind. But those certainly medical devices would be one area of the goods that are under regulatory oversight. Another is in aerospace, and that's in an area that Stratasys has been very involved with supporting its customers. And in fact, over the last 3 years, we've developed and introduced a certified aircraft interiors solution, we call it, where Stratasys has worked very closely with the regulatory industries in getting our materials approved and demonstrating that they meet the specifications in those industries. So we did cite to, in our briefing, we cited to materials that are posted on the Stratasys website. And I also have a handout that I can give you if we want to mark it as an exhibit that further explains that, that particular offering that we have, and it really explains the end-to-end of how the materials.
Maybe you should
go ahead.
pass around that now. And
Okay,
call
sure.
it Exhibit 12A if you're going to be speaking about it now. If you can show it to, do we have it?
So it explains the end-to-end of how the consumable materials, the software, and the printers are all so closely tied in an integrated and closed system, and the importance of that. How should we go about marking it as an
Okay, so
exhibit?
this is Exhibit 12A called Solution Guide Certified Additive Manufacturing for Aircraft Interiors, and we'll make sure the court reporter has a marked copy.
Okay.
So, I had a question about some of the evidence you submitted regarding the FDA. We talked about this leapfrog guidance, which is not a regulation and it's not binding. How are we to interpret that?
So that would be a non-binding on the users of printers making goods for medical devices. So I guess that would be not maybe to the level of legal regulation, but there certainly are regulations governing, that are binding, that govern medical devices and would apply whether you're manufacturing those on a 3D printer or otherwise.
So is that something where that there is legal or regulatory oversight or a related certification process?
So in my view, yes, the medical devices would be subject to legal and regulatory oversight, and then would thus be within the qualifying language of the current exemption. So in other words, by removing that qualifying language, as has been, urged by Mr. Weinberg and the petitioners, that would allow users printing the medical devices to circumvent the TPMs.
So Mr. Weinberg asserts that maybe the existing exemption and that limiting clause is overbroad, and we have some examples of the FDA, maybe the FAA. Are there any additional examples to offer in terms of regulatory language?
I don't have additional examples of regulation of parts, but I think what we're looking for is examples of users who are adversely impacted by that language in the exemption. So in other words, those who are adversely impacted by the use of TPMs on 3D printing materials in regulated industries, and I don't know of any examples of such persons.
What would you say in response to, I guess I'll paraphrase Mr. Weinberg's contention of, what a regulated industry is, or a regulated process in commerce is hard to figure out whether you fall in or out of that. You may be just making a dish or something, or that would, if it was a sculpture and didn't involve 3D printing, you might not have to worry about. But for some reason, it's unclear whether you could make use of this exemption in that example.
Right. Well, so the language extends to 3D printers that produce goods or materials for use in commerce. So for one thing, if you were printing something for your own use as a maker or something, it wouldn't apply. But let's say you're putting it on selling something on Pinterest or something, like maybe that would be an example. This isn't in the record, so we haven't heard from any of these people, but like, let's say there's somebody making something and selling it on Pinterest. I wouldn't consider that to be something that would be subject to legal or regulatory oversight. So I would not consider that within this, I would consider that to already be exempt. And, unless it's, medical devices or something, I think it's pretty clear, if you're producing goods in a regulated industry, that you're doing so, and we haven't heard from any persons in those industries who object to this language.
Mr. Weinberg, did you want to respond?
I would argue that if you are selling something on Pinterest, you are subject to a large number of regulations. And
But are you subject to a regulation over the physical production of the thing you're going to be selling?
Those extend. If you were to manufacture something that was defective and sell it on Pinterest, then you would be liable under a legal or regulatory regime. And I also want to clarify that the language as it is written right now covers a 3D printer that produces those goods. And so it's not as if you had one 3D printer that was sometimes producing things that were for purely personal uses and other times being used to produce things for commercial purposes, however we're defining that within the scope. You would potentially be in a situation where if you were using that material for one purpose and not another, you'd be in an ambiguous space. And it looks like you have a question, but
I wanted to see whether Ms. Chapman knew whether the 3D printers, whether that's true, you'd use one printer for the different purposes Mr. Weinberg is saying, or maybe you know.
Well, in the 2015 proceeding, the Copyright Office actually asked for a distinction between commercial and non-commercial, and Stratus's response was, the first heading is, there's no meaningful way to differentiate between commercial and other non-commercial uses of 3D printers. And it goes on to describe in detail, today, quoting again, an individual 3D printer may be used for a quote-unquote personal or non-commercial use one day and for a commercial purpose the next. For example, engineers and designers may have 3D printers in their homes, but use them for inspiration, experimentation, and prototyping that blend into their work. The same 3D printer may be used for other household members, for personal hobbies or school projects. The point is that they're general purpose machines. And just as you might use your computer or even a work computer to do things that are a wide range on a spectrum of commercial and non-commercial purposes, these 3D printers are being used. You think of 3D printers that are in libraries today, that are in maker spaces in libraries. Very often those are explicitly advertised at places to come and do your own projects or potentially start a small business.
So the active circumvention, is it done each time you need to use the alternative filament, or is it, just once, okay, you've broken it, so it's open?
It would really depend on the TPM being used. I think that the canonical TPM that it was kind of used as the model for this is a chip verification system, in which case that you would be breaking the TPM every time you load new filament in. But again, that could potentially vary based on what's going on. And I think just to reiterate the point, the concerns that are being raised here are very far afield from the scope of Copyright Office, right? We're talking about the integrity of the airline part production process. We're talking about medical safety. These are not concerns that are grounded in the types of concerns that motivate copyright law. And they're not the types of concerns that I think that a petitioner should have the burden of being able to refute in a proceeding such as this.
So I wanted to jump in and highlight that the language that was adopted in the 2015 exemption, it didn't follow the lines of the commercial versus non-commercial use that was briefed by the parties. So I think that the Copyright Office was really quite thoughtful and really prescient in its decision-making, in that it focuses on the 3D printer and whether it produces goods or materials for use in commerce subject to legal and regulatory oversight. So that's different from just a breakdown on a commercial versus non-commercial use, because in the case of somebody with a home business, selling the printed parts, that could be a commercial use. And so that's sort of the context in which, we were responding on whether that was a principled, differentiator. So I think that the work that was done in 2015, it really did result in something meaningful and an exemption that makes sense and is appropriately, directed to the types of uses that the office and the register were concerned about in 2015. I mean, Stratasys had, in that proceeding, we had objected to the exemption, in full. It was the first time it had been considered, and we objected to it, and then when it kind of was narrowed down, and then in the post-hearing questioning was sort of getting towards how could it be written to differentiate, what the result of the work that was done, it is workable, it's not ambiguous, and it sort of got dug deeper than just commercial versus non-commercial. And I think it, quite appropriately defines the goods and regulated industries. And there aren't any examples given on the record in 2015 or today of persons making parts on a printer that's used to print things for regulated industries and also for, a non-commercial, like hobbyist or home use. That just isn't happening.
Mr. Weinberg, I wanted to go back to some discussion about the FDA. We had that leapfrog guidance. I wanted to get your reaction on how to interpret that, and also how to interpret the letter that the FDA sent to the Copyright Office, which did discuss 3D printing, but was not in response to a 3D printing question. It was in response to a medical device question. Was it important for the FDA? How are we to interpret both those FDA actions?
Yes, thank you for the question. So I think that in terms of interpreting the leapfrog guidance, I think the primary way to interpret that is that the FDA is fully aware of this technology and has instituted a process to examine the technology within its regulatory scope. And so to the extent that the Copyright Office would be motivated to act because it was concerned that the FDA was somehow ignoring or abdicating its responsibility in connection to 3D printing, the leapfrog guidance makes it fairly clear that the FDA is deeply involved in a review process. And again, I'm not well positioned to evaluate the effectiveness of that process, but I will defer to the FDA that it's enough to say that it is something that they are focused on and fully engaged in. In terms of the letter, I believe, and I have the letter here, my understanding of the letter is that it was written in response to questions from the Copyright Office regarding a number of different exemptions. So it was written partially in response to the existence of the request in 2015 for this exemption. Looking at the letter, the vast majority, it's a 5-page letter, the vast majority of it focuses, as you would expect, on the exemptions specifically related to medical devices. And within the context of 3D printing, towards the end, it's the fourth point, the FDA says, regarding 3D printing, manufacturers who utilize 3D printing to ultimately manufacture devices need to ensure that their products are safe and effective for their intended use. Which, again, I interpret the FDA as saying, we regulate medical devices, and we have existing regulations that are divorced from the manufacturing method. And we have that regulatory regime. If you make something that is a regulated medical device, if you use a 3D printer, if you use a 3D printer with third-party stuff, if you use a kiln, if you use whatever you want, it has to meet these standards. And that's how we, as the FDA, have decided to construct this regulatory regime.
Leapfrog guidance, though, is for developing technologies, like new technologies. Do we have any expectation that we'll see more regulation from the FDA that's eminent? This is to either party?
I'm not an expert on FDA regulation. So what I can take from the existence of that guidance is that the FDA is fully aware of the technology. I think that guidance, if you read the leapfrog guidance, the guidance largely says that the FDA has existing regulatory processes, and it is a reminder to manufacturers that whether they're using 3D printing or not, they are responsible to live up to those standards. And so whether or not there's going to be additional regulatory guidance from the FDA, I think that you could fairly interpret it as there's an intentionality to that decision-making at the FDA. If the FDA believes that there needs to be additional regulation, they're in a position and aware of the potential problems to do it. And if they decide that they do not need additional regulation because their existing regulatory regime is robust enough to handle a different type of manufacturing technique, then that is a decision made, again, with intentionality.
So we have a 1201 exemption that's existing, but in the record last time, we also talked about the fact that some 3D printers may not have TPMs on them. Others may not have TPMs, but they don't effectively control access to the work, and might not need an exemption. Can you tell me, of the uses that would be involved in this expansion, do any of those uses, are those covered by potentially other ways to get this done?
So sorry, is the question that, would some of these uses be achievable with printers that don't have TPMs?
Right, where you need to demonstrate we've said causation is an element of something that we're looking at. So is the prohibition on circumvention causing, some impediment to these, an adverse effect to these non-infringing uses that you're seeking to expand?
Sure, I understand. So again, I don't have survey data on this information. If
Any data.
Right, so I'm if it would be helpful to add into the record specific examples, that is information that I have not pulled together prior to this, but it is something that I'm happy to follow up with. That would be helpful.
Ms. Chapman, do you happen to know whether the trend in 3D printers is to have more or less TPMs on them? Or, did you want to speak to that question, if you may know the competitor products?
Actually, I don't think that there has been any trend to have more TPMs. I think it's been, I think it's similar to what we, the marketplace in 2015, that there are printers that are not locked with TPMs and there are printers that are. I'm really only, an expert on our own printers, but there still exists, the printers that weren't using TPMs 3 years ago, to my knowledge, they still aren't.
Do you have any evidence, to point to show that the circumvention of TPMs, or any reason to think if this modification were granted, it would have an effect on copyrighted works?
I do, because the TPMs are protecting access to copyrighted works.
The software on the printer.
The software, the operating software on the printers. So we had talked about in the previous proceedings that it's not really clear, and certainly not in all cases, is there copyrighted software on the chips that protect the consumable materials. That's not, maybe in most cases, isn't copyrightable work that's being circumvented directly in avoiding a chip protection of use of third-party, like unauthorized filament. But the way that the closed systems, like the Stratasys printers, the way that they work is that there are sets of system parameters designed that operate depending on the type of material that you're using. So when you insert the material, the printer reads the chip to see what type of material is on the chip. And then it sort of does a handshake where then, based on that material, the software configures the parameters that we've set for that material. If you've introduced a material that doesn't have a set system of parameters, and it needs to operate at like different temperatures, there's like a whole host of complex system requirements that have these, that are impacted by what material you use. But if you have something that isn't within the set parameters, you would need to go into the operating software, which that would be a different circumvention. That would be circumventing the password protected access to the software running on the printers, which is not, that's not something that we enable our customers or users to do. So there would have to be an access into what we call the back end of the system and going in and modifying the software to accept a different material. So then that would be the copyrighted software.
Okay, and then I think the answer to this question must be yes, but is it your view that if this, Mr. Weinberg's petition is adopted and this limitation is removed, there's specific types or models of 3D printers that now become fair game for circumvention that are not fair game now?
Yes, exactly.
Could you speak specifically?
Specifically, so there are printers that are being used to print parts that are put into commerce and used in these regulated industries. So right now, those printers would be subject to the standard, copyright law that prohibits circumvention of TPMs. They don't fall within the exception. So a specific example of such a printer is, and the offering I referenced earlier this morning, that we have we call a certified solution for aircraft interiors that involves a particular printer, particular licensed software, and particular consumables, all operating together. So those presently would fall within this qualifying language, so their circumvention is not permitted. So if that qualifying language were removed, then it would be permissible for a third party to circumvent the TPMs that right now make that a closed system. And
Okay,
so,
and just so I understand in connection with this may not, is your product, is this the Fortis 900 MC or what printer are we talking about?
yes, the particular printer is, it is a Fortis 900 and it's loaded with specific software and a specific print head that is provided to the customer with this certified package. So it would be the printer, the 900 is a printer that we offer more generally, and it's not necessarily printing parts for commerce. I mean, you could be using that and printing prototypes that are just used within, your facilities, a non-regulated use. So that particular printer, the Fortis 900, there's uses of that printer, and there are users who use the printer for, in manners that would fall within the bounds of the current exemption rather than the qualifying language. So in other words, it depends on the use that you're making of that printer, and certainly there are uses that are not, that are exempted. And
Okay, so in your view, maybe a non-configured for aircraft Fortis 900 is general purpose, would be you'd be permitted to circumvent that under the exemption, but not once it's been sort of configured for the aircraft specific, just understanding where the bounds of where the
Well, that would be
exemption
one
lies.
example of, that aircraft interiors package would be one example of something that would fall outside of the current exemption, but there are others as well. Even without that particular software and that particular package we offer, the
Is that
custom,
typical?
oh, sorry.
Is that typical that you'd configure the printer with specific software to comply with, a manufacturing purpose?
No, this is, it's more of a unique offering. It's sort of like a direction that we're going in the industry to enable greater adoption of 3D printed parts for manufacturing vertical applications, but it is not something that typically that we've offered. So more in the typical offerings in the past have been general purpose. So then it would come down to, as far as applying the current exemption for those printers that don't have this specific application-specific software, it would come down to looking at that particular printer and assessing, whether that 3D printer is used to produce goods or materials for use in commerce, subject to legal or regulatory oversight. You would have to, it would be on a case-by-case how that printer is being used.
I just want to clarify some stuff that's in your exhibit on page 8. Point 4 makes mention that parts by themselves are not certified by the FAA. But later, it says in point 7, if parts and materials aren't certified by the FAA, why is it called certified? And it discusses that the printer using a controlled specification process has been audited and approved by the FAA.
Right.
So I guess and back in point 4, it says, the parts are not certified by the FAA, but are approved by the aircraft's overall certification. I guess the issue is, when we talk about the production of goods that are in commerce, how taking Mr. Weinberg's point, how are people to understand that there's so many intricacies here? How can they make sure that which certification process and why maybe you refer to the process of approving the printing process by the FAA is confusing. Can you react to that? And I guess, is there a difference between the goods and the process of the goods in terms of other certifications?
Yes, you're correct. There are a lot of intricacies here, and when with the regulatory bodies and regulatory agencies. What we've done with the certified materials solution, we've done a part of the step that a manufacturer of goods to fly in space needs to do. So there's like the material qualification process, and then a specific part also needs to be qualified. So we're kind of putting out, I guess, making it clear that whatever part that a customer decides to print is still subject to FAA oversight, much like Mr. Weinberg mentioned that the medical devices printed on a printer are subject to the general, rules of medical devices. So you don't need a specific, the rules don't have to be specific to 3D printers. There's a general body of regulation that applies to these devices regardless of how they're made. So what we've done is, like step 1 or a few steps or something of the process, so that the FAA has already given its general approval of use of our materials as printed in this closed system for printing parts in aerospace. And there's specifications that have been a specification that's been developed and approved. So we have all different properties of the material and the parts that are printed using the printer with a particular material have been vetted through all of this regulatory oversight, and that's been approved, so that when you're using our closed system and your output is something that they will approve for their for flying on aircraft. But a particular part that's printed still might have to be approved for that part design or other particulars, of which, honestly, I'm not familiar with all the details because the customer is doing that pice of it. But it is a highly regulated industry.
Mr. Weinberg, maybe you can react to the challenges, to what the opponents just said, but also the challenges of trying to conform printing to regulated or certified goods versus a process versus a downstream use. Are any of those easier than others or clearer?
I mean, I think what this illustrates is it's complex. right, that there is a complex web of regulations when you're manufacturing anything, whether it's an airline part and you're navigating FAA regulations, whether it's a thing on Etsy and you're worried about Prop 64 compliance for, lead-free items. There are a number of potential regulations that attach to anything that you are injecting in the stream of commerce. And I think even in the context of this FAA regulation, if you're using this closed process, it's not 100% clear to me how it works. I'm not an expert in that, but it seems that process is somehow recognized and understood by the FAA. And if you were to introduce unapproved third-party materials into that process, is my presumption correct that you would then fall out of compliance with that system? So the FAA regulatory process is robust in the sense that it's designed to handle a specific set of situations. And if you, as a manufacturer, decide to bring in elements that are outside of that regulation, the FAA knows how to handle it. They will say, you're no longer certified. And so as a manufacturer, maybe you decide that's worthwhile because you can go back and get certification through the FAA, or maybe not. But again, all this is very far afield from concerns of copyright.
And we appreciate that perspective, and it's something we're looking at seriously. But just to focus on building out our record in other areas too.
Absolutely.
Ms. Chapman, aside from aerospace and I guess medical device regulation, what other regulated industries, is prompting a concern with Mr. Weinberg's, pitch for a slightly different regulatory language?
Those are right now the primary regulated industries that we've been working in. So as far as what's, prompting Mr. Weinberg's concern, I can't really speak to that because I don't have any examples.
I guess your objection to Mr. Weinberg's petition is what I'm looking at. It's mostly driven, I guess, by those two regulated industries as areas of concern.
Certainly I foresee as we expand manufacturing into additional verticals that there are other agencies. We do work also quite a bit with the automotive industry, and it's not nearly as tightly regulated as aerospace. So we haven't worked with our customers, on an example that I have of a tightly regulated product. But certainly there are regulations there.
And then what would you say, again, I'll just sort of paraphrase, I think Mr. Weinberg's point is if something is regulated by the auto industry or an agency charged with regulating that that is a totally separate regulatory regime and not something that the Copyright Office should be considering when looking at the exemption.
Well, I think that it's getting maybe a bit twisted around because the Copyright Office has a blanket rule that prohibits the circumvention. And so, we're not, as the 3D printing, manufacturer aren't coming to you asking you to write rules that supplant what's already in place by regulated industries or, in other agencies. We're merely asking that you continue to limit the exemption so that, because there hasn't been the adverse impact and the harms identified that support an expanded exemption, and that under the fifth factor that is considered or to be considered under statute in making these exemptions is the other, other considerations that the librarian deems important. And in the previous proceeding, these safety and health concerns of using the printed parts in regulated industries for manufactured goods is something that was found, to be deemed worthy of consideration and was considered in making this rule. And so we believe that is appropriate.
So let's say that either you have a 3D printer that is used in a heavily regulated industry, or maybe you are a user who happens to work in one. Would modifying the software on that printer in order to use a third-party feedstock be more likely to be infringing on copyright, or maybe the same, or maybe less? Could you walk us through that?
So in modifying the software to accept consumable material that is not authorized by the manufacturer who uses a TPM, I believe would be copyright infringement.
But
As it's not permitted under the license terms.
Okay, and is that different because it's a regulated industry versus, folks who are covered by the exemption right now?
In terms of whether there's a copyright infringement, the difference in, I guess there's a consideration between whether a commercial versus a non-commercial use, just in the fair use determination. So I think that for, again, that's commercial versus non-commercial isn't exactly the split that we came up with in the current exemption. But if you look at commercial versus non-commercial, the non-commercial user has, the benefit of the fair use factors, where a commercial use would weigh against that.
Okay. What about the Section 117 analysis? Is that any different?
So Section 117 is in regards to the owner of the software, right?
Owner of a copy.
So there's license terms that are typically with the printers placed on the software that's provided and that operates the printers. So we don't believe that enables.
Are the license terms more restrictive in a regulated industry necessarily? Or?
Typically, I guess it depends on the printer, because some of the printers are running on really more of an open source software. They're not necessarily getting the software from the printer manufacturers. So there are some softwares that are available and that they're intended for users to be able to change the parameters and things like that. That's not what we're selling with the Stratasys printers, but certainly that's something that that is available. So like persons are under the current exemption able to change parameters on software if it's an open system.
Okay, thank you. And Mr. Weinberg, did you have any thoughts on that?
No, I mean, I think that Ms. Chapman understands the nuances of the licensing of her machines far better than I will. I think that my sense is that generally speaking, there are not licensing distinctions that are being made between, based on the application in the industry. And that generally speaking, these machines are sold as the general purpose machines that they are across the board, and there are not a number of legal distinctions between applications and uses in terms of the copyright. And I mean, again, I think your raising of 117 is worth circling back on a little bit. And I don't believe that there are concerns being raised that there are standalone markets for the software running these machines. And the kinds of concerns, and I apologize to keep circling back on this, but the kinds of concerns that are being raised are not the kinds of concerns that we're talking about with regard to infringement of copyrighted works. We find ourselves in a situation where we're talking about a bunch of potential harms that are beyond the scope of that. And a lot of this proceeding, when it began, was really about clarifying that the Lexmark precedents in the 2D space applied to the 3D space. And I think there's a lot of value in that, separate from, this is going back to the fifth factor, separate from the specific legal status, but being able to clarify that those precedents cleanly translate into 3D space to avoid the 10 years of litigation that I think we're all pretty familiar with that was tied to that. And I'm appreciative that the Copyright Office took that step in 2015 and is looking again to renew it now. My concern is that the qualifying language that was included has muddied that water a little bit for a purpose that is unclear to me. And so the harm in complicating the analysis is not outweighed by a related benefit. But going back to your original question, I don't think that there's a lot of legal distinction right now based on regulated and unregulated spaces.
So I guess in the last proceeding, there was a comment in our recommendation that there was not enough in the record regarding whether the software on 3D printers is subject to, someone who owns it versus if it's licensed for 117 purposes, except for some evidence of Stratasys' own printers. There was no evidence of industry-wide. Is there any more evidence of that in the record, or?
There wasn't any evidence on that put in the record in this proceeding. I did want to maybe just clarify that I guess I agree with Mr. Weinberg that there isn't license terms aren't based on the use. It's really the printers are, typically sold as general purpose, and so the license terms that apply whatever your use is, but that
do you have different license terms for like the add-on software package for the particular aerospace use?
We do not. We have,
Thank you.
it is licensed, but it is not a separate, or it's not different, it's not more restrictive terms. But I did want to point out, again, that some of the software that is designed to be more open and that allows and enables use of other feedstocks, the software would be licensed, but it might allow the user to control a lot more variables and parameters, even under license. Just because that's how the software is, the flexibility that is built into that software.
And we're still talking about consumer-focused additive printing, not commercial lathes or anything like that.
Well, typically, I think typically that the systems that are more open would be, tend not to be used in the regulated industries, but I don't have any facts of that. I don't have any facts to support that. Nobody's put anything on the record about that.
Speaking of the record last time, I wanted an update. There was a kind of an assertion, but not a lot of record evidence about whether there might be, piracy of operating systems on 3D printers. Do we have any evidence of that? Have we seen that change? Are they, trading on pirate sites these operating systems or no?
I have seen that. I've seen that since before 2015, where there is software that has been available on eBay, for example. There's been, particularly, we've had some issues originating with actors in foreign countries, then putting our copyrighted software into these forums and offering it so that you could, a use that they're sort of targeting is that you could get our most current software and put it on an older machine and kind of like build your own, newer model using your existing older printer. So there has been some of that.
Is it your position that removing the limiting clause would encourage that?
I guess I haven't thought about the TPM protection as encouraging or discouraging that one way or the other. I think that's subject to the copyright licenses and it's protected in that manner. I'm not sure that it's a TPM issue, although, I guess maybe you have to look at how do they download the copies. I'm not sure.
Well,
that wasn't, I guess that wasn't something that we were considering with the exemptions.
So we're discussing access, though, of access to the computer program on the 3D printer. It's not, these additional issues of health and safety are, an additional consideration, but as this is exemptions for copyrighted works. I guess, does Mr. Weinberg have any follow-up thoughts to that, or?
I mean, I think that the fact that as part of this proceeding, we've not given a lot of thought to whether or not TPMs have an impact on infringement of the actual software on the printers is a relevant data point, considering what are the concerns that are driving objections to this exemption request, and that the focus has been on things that are unrelated, and the fact that we don't have great information on, or no one has given much thought on the impact the TPMs would have on infringement of the operating systems it seems very relevant to me. And I would say, secondly, that if you're breaking TPMs for the purpose of infringing on the copyright of the operating system, for the purpose of making that software available to someone else who has the printers, that would be a purpose well beyond the scope, certainly the intended scope of any exemption being discussed here. This is not an exemption designed to allow people to take software off printers and move them on to other printers, right? This is designed for people who are lawfully in control of their printer and want to bring third-party feedstocks.
Ms. Chapman, you look like you want to respond, is that?
No, I guess maybe I'm not sure that I disagree with the response that Mr. Weinberg gave on that.
Okay. Did you have anything else that you wanted to show us in this hearing? You mentioned maybe other exhibits.
I
If
did
not,
bring
that's fine.
some sample like test coupons to show what part defects, so that you could see like the type of control that we're attempting to get in the printers, which the the TPMs kind of we benefit from the TPMs, in being able to provide these kind of closed systems, and our customers, the manufacturers, benefit as well from the TPMs and the certification and validation and traceability requirements that are placed on them by the industries. So I did, if you care to see them, I did bring some
I think
parts
if
that just
that's
kind of
something-
illustrate that.
If that's something you'd like to enter into the record, now would be
Sure.
a good time to do it.
Okay.
So we'll start with 12B, or I don't know how many items you have.
Okay, yeah, I just have a handful of items.
If you want to just pass them around to
Sure.
Mr. Weinberg.
So these are test coupons as they're referenced in the literature that was circulated as an exhibit earlier. So to put some, put a face to that. So there's two examples of test coupons that are printed without defects. And then there's one of them, it has just some slight black markings in it that, sure. So this is the one with the defects. It just shows the level of control that's needed in order to avoid part defects, because a defect is where parts fail. So that's what we're trying to avoid. So the black marks on this, just if you want to pass that around, it just shows where the material has overheated for one reason or another. Maybe there was something, particles that were caught in the nozzle and overheated, or maybe the temperature of the extruder was too high, but in any case, it darkened some of the material, and that will lead to a defect. This is one of the test coupons. So we print these, and then there's tests, and there's tests to see what force that they can withstand. So this is just showing where a break from one of the tests, and the break was at a defect, which the defect is, if you kind of put it together, you can see just a little blip, and that's where the breakage occurred.
And how do you discover these defects?
So those test coupons are printed by our customers, by users of the printers, when kind of the like sophisticated users that are needing to get very specific results. So those particular coupons were printed in connection with the aircraft interiors certified parts, but those are test coupons that are done really on all of our printers. So even though not within a specific package, we just generally enable the customers to be able to print these test coupons and validate their parts so that they can meet whatever requirements that they need to meet in their part strength, and to validate that the printer is operating according to all of its operating specifications of the closed system.
So I saw that one piece was broken, but I don't understand what someone would see where that black dot was. Yeah, tell me more about how they're looking at these items to see if they're not up to snuff.
Right, so you could see like where the black marks are, you can see that there is defects, even without testing it. So
And
that
so
one
they
would,
visually inspect it then, is what you're saying?
yeah, so that would be inspected and it wouldn't pass. But then you also, they'll do the force tests on them to see, to verify that they pass as well.
And these parts that are defective, were they made with replacement filament?
No, this is made with our own, it's made with Stratasys filament, before before the, commercial, manufactured part would be produced. They would, validate that the system is operating according to its own specifications before printing the parts.
So I get that there's maybe multiple levels of making sure that the specifications are up to the certain standards, but wouldn't someone who's using replacement third-party filament using this exemption to do so be able to visually inspect those parts?
They would be able to.
Okay.
I have just a couple of other examples since I have them here. So this is also a test part. This is a more, not a coupon, but it's a test part that's designed to, show the different tool paths and give a wider range of printed geometries to look at in the testing. And that one's one that passed. So that's just an example, again, of the kind of qualification that's done on these printers. And then this piece that I have in my hand, it's a portion of a part that actually is made to fly on airplanes. And it has on one face of it, it has kind of like a nub that isn't intended to be there. And so that would be a defect that doesn't pass the inspection as well. So yes, people would be able to examine these defects, whether they're using our materials or other materials. But the importance of all of this is just that the TPMs are part of what plays into that closed system. They're part of what assures, that 3D printers are producing trustworthy parts. And particularly, it was something that Pat Carey addressed in 2015, is that where there's multi-levels of suppliers, these multi-tiered suppliers, there's a concern that somebody in the supply chain is going to want to save money and use a cheaper material.
Okay, thank you. And just in terms of housekeeping, I think the first collection of coupons we're going to call 12B. The one that I want to say looks sort of like a clock, we're going to call 12C. And then the airplane piece that you've just referred to last, we're going to call 12D.
Okay, thank you.
First, I want to ask if my colleague from NTIA had any more questions, then Mr. Weinberg, if you have any final responses.
No, I think I really appreciate that you're taking the time to consider this, and I recognize that there have been a couple questions about specific evidence. I think process-wise, I'm happy to provide that or not provide that as it's useful. I guess I will wait to hear if there's a request.
Thank you. Yes, in general, after these hearings, the office is going to take a look at what we've got for each of the classes, and if we find the need to issue post-hearing questions, we'll do that to the participants for that specific class. So we appreciate both of your time very much. I think we're going to adjourn now and then come back at 11 o'clock for what we've termed audience participation session. So thank you, class 12. And then if anyone else is interested in participating, there we have a sign-up sheet, and I think we'll get started right at 11, and we'll probably not go all the way to 12. So thank you.
Thank you.
Thank you.
This has been a presentation of the Library of Congress. Visit us at loc.gov.